Professor with the U of A Faculty of Law, and this panel concerns practices innovating the content and delivery of legal education. So this is the practice, rubber hits the road, how-to panel. We're going to have 4 presentations, and just a couple comments about that. First of all, having heard Hugh's presentation, I really would have liked to have heard a presentation on bringing the virtue of the teams to the law school. Though I've got to say, our law school has vigorously rebuffed my suggestions that we do compulsory 5 a.m. PT. We have had a couple of former and current first-year students of mine here in attendance, and I got to say, they'd say SEAL's got it easy. Become a SEAL got to get through Hell Week, but they had to get through Hell Year with me. So we do have, one other little thing. You'll notice Professor Deborah Cantrell's name is mentioned in the program. Deborah apologizes, can't be here. You'll all have heard that there was flooding in Boulder, and unfortunately Deborah got hit by that, so she's got plenty to attend to on the home front. Deborah's paper is available on the website, and that concerns clinical legal education. So for our 4 presenters, we have Dean Lorne Sossin of Osgoode Hall Law School, formerly a professor with U of T Law School, and was the first director of the Center for the Legal Profession there. He'll be talking to us about Experience, the Future of Law Education. Then we have Professor Jerry Hess with Gonzaga University School of Law, who is a very well-known author in the area of teaching and learning and legal teaching and learning. Been working in this discipline for a long time. Founded the Institute for Law School Teaching in 1991. He'll be talking to us about qualitative research on legal education, studying exceptional law teachers. Then we have Stephen Henderson and Joseph Ty, and I'm glad they could make it because Peter Sankoff took them out in the town last night, and I don't know if they just rolled in here from wherever it is that they were just before they got here, or whether they just woke up and made it, but they're here and we're glad. Steve and Joseph are from the University of Oklahoma College of Law. They are co-creators and co-webmasters of CrimProf Multimedia, which is an online media and pedagogical resource for criminal law and procedure professors. They're going to be talking to us about crowdsourced casebooks. And finally, my colleague Peter Sankoff, with the University of Alberta Faculty of Law, did some time at University of Auckland. He is the 2013 recipient of U of A's Teaching and Learning Enhancement Fund Award on the role of technology in the flipped classroom in legal education. And Peter will be talking to us about taking instruction of law outside the classroom. What does the con economy have to do, or have to teach us about law teaching? Without further ado, Dean Sossin.
Thanks very much. So I almost hate to interrupt all the wonderful discussions that have been happening over lunch with the panel, and I felt that way this whole conference. It's been the informal interactions and connecting faces with names, with work, with ideas that's been such a rich part of this. So thanks again, as many other contributors have noted, to the organizers and to the University of Alberta for making this possible. And it's also nice to come on one of the last panels because you get to tie in your thoughts with so many of those that have come before and also build on some of the questions and controversies that I think have constructively come about so far. Picking up on John McLaren's point, I'm here to add a positive note to the discussion. I've got a feel-good topic, and of course it's probably the Kool-Aid Dean's drink to feel good about a future that you're committed to being a part of, but I feel that there has never been a better, richer, more engaging time to be in the business of legal education, notwithstanding the challenges and pressures, and maybe because of them. They create great opportunities to try different approaches, to build on what works and to challenge what doesn't. And I want to suggest to you one of the things that I've found works, and I'll be speaking generally, but also from my perch at Osgoode Hall Law School, is experiential education. And of course, I'll try to define what we mean by that, because we've heard already both comments celebrating it and comments with a note of skepticism, and I think both are probably right, but it all depends on, of course, what we mean by it. So I want to talk a little bit about why this has become such a dominant trend sweeping law schools throughout at least North America, and also why I take it to be a good thing. And I've come to this over time and over my own lived experience. I was not a clinical aficionado as a student at Osgoode, and I've gotten involved in experiential contexts really driven by looking for better ways to teach, looking at better ways to be a legal educator, better ways to learn, and I'm convinced for a host of reasons that if done in the spirit that we've been hearing, so it's reinforcing a knowledge community, so it's enhancing critical faculties, and so it's engaging the kinds of skills and understandings that will help students later in their careers. If it's all of those things, I think I've come across no better model, and particularly because it also is moving, as we've heard from many, from a curriculum based on conveying knowledge, which is quickly going to be replaced by any good search engine, to a way of solving problems and doing so through analytic frameworks. And that seems to me much more akin to what we all are excited about in legal education than the conveying of a specialized body of knowledge. And I also feel kinship with the other presenters because there's also a lot of reinforcing opportunities between digital legal education and experiential learning that in turn enhance the collaborative approaches we've heard Hugh and others talk about, that enhances the ability to have accessible legal education, which is probably something we haven't heard enough about, and I hope is part of this discussion. So with all that, like the fading in and out, why experiential? And here's the key problem. Carnegie report, Stuckey report, these have been mentioned by many. And I really do think it's unhelpful to engage in an artificial dichotomy between preparing thinkers or lawyers. And I've mentioned this in one of my questions, and I know others have come back to it, because these seem to me inherently and organically linked and reinforcing goals. And so when I say I'm drawn to experiential legal education, it's simply because it's a better way to construct legal education. It's not a better way necessarily to prepare lawyers. I don't think that that's really a debate in which we've heard the best evidence-based conclusions, but I can tell you it's a better way to teach and learn in law school, and that ought to be enough to drive innovation forward for this community, I think. So one of the reasons is, again, looking to our lived experience, data on how people learn and why people learn, and this takes us, Doug, even beyond Confucius to what social scientists have discovered about different learning environments. And anecdotally, as a dean, you get to go to lots of alumni events, and so I have my own unscientific surveys as you talk to people 10, 20, 30, 40, 50, even 60 years after graduation and say, what do you remember? And invariably what stays with people is the experiential. It's not the necessarily, Alice's class with Ernie Weinerib that I come across more often, although those are meaningful moments, and I don't want to suggest we don't all aim to have the light bulb go off for our students in exactly that way. But invariably, I was mentioning at dinner last night, we had Andromeda Karakatsanis come back to Osgoode, who's a Supreme Court of Canada member and had been a part of our Parkdale clinical program, and it was her first experience with any young person who with no family in need. She came from a close-knit Hellenic community, and family just took care of each other. First time she had ever seen a world in which someone lived without any nets beneath them, and to be a positive part of redressing a situation like that simply defined her understanding of law as a profession and what a lawyer could do for the rest of her career, and continues to today, which was wonderful to have her come back and talk to Parkdale students today about that. So experiential learning in both scientific and anecdotal ways clearly resonates in a way that no other kind of learning, I would suggest, does. Second, of course, we've had the considered interventions of these task forces policy and I'd suggest none has come up with a coherent argument as to why we shouldn't have more experiential programs. And I think if you go back to the goals of law and learning, for example, which we've talked a lot about from Harry Arthur's contributions some 3 decades ago, straight through to the most recent forays on best practices in legal education, I'm simply aware of none in which the idea of well-conceived and well-delivered experiential education isn't a high watermark. It doesn't mean it's the only way to deliver legal ideas, and of course is ideally connected in a sequential way with building other foundations and taking experiential insights to other places in legal education. So it doesn't exist in any kind of island or silo either. I want to suggest also the collegial element, which again we've heard less about today, that experiential education works when there is buy-in from an academic community. And you heard Doug mention the Osgood decision to build this into the, what we like to say, not so much as a requirement, but a universal opportunity at Osgood for every single student to have an experiential component needs to be, I'd suggest, a collegial impulse. In other words, what we're saying is, Vic, coming back to John's comments, is a wonderful institution and I have nothing but the highest respect for it, but it's accepting that 25% of the people in any given class can have no experiential component, and that's fine, and they can still get a law degree that Vic is holding out there as preparing them in every sense and way they need to be prepared. Osgood's making a different claim. If you haven't had an experiential component, your legal education is simply incomplete as we understand the term. We have the same universal opportunity for public interest placements because unless you've been alive to the needs of community and engaged in leadership in those contexts, we would say there's a public element of a legal education, at least in this country, that's been missing. And that's how it should be. We should be making claims. Other law schools will make different and other claims that should also be contested and defended in exactly these kinds of settings. And I don't want to suggest what works for Osgood ought to work for every school, but I do want to suggest that Osgood's not simply saying we think this is good for Osgood. We're saying we think this is an essential element of a legal education and would be defended on the same grounds as why we think torts should be taught in first year or why we think there should be an oral component to lawyering, negotiation, and mooting skills, or any other element that we say is required. So at Osgood, there was a decision taken on the recommendation of the curriculum committee to adopt this, and the requirement, just to outline it, it's very simple, has three elements to it. For a course, program, seminar to merit being included in this experiential component, which is usefully called a praxicum, because we knew that would roll off the tongues of all the prospective students, are these. So one is immersion in the ideas in that field of law. So if you're doing Parkdale, you would be immersed in poverty law. If you're doing the intellectual property intensive, it would be an immersion in IP, business law, innocence clinic, mediation intensive, disability intensive, anti-discrimination intensive, the list goes on and on. You begin with usually about 2 weeks of intensive everyday classes to understand the foundation of ideas in that field. Then comes the participation in or exposure to the doing, and it could be delivering legal services, it could be involved in organizations, collaborations with outside institutions, simulations in class, in clinical and many other settings, externships, all of the above. And finally, and we think most importantly then, the third element is the reflective, to come back together and connect the dots between the immersion in the ideas and the exposure to what those ideas are like in action. And if you bring together those three in any of these settings, whether in-house, external, delivering services, or providing other kinds of support to organizations, then it counts. And we went from a count of about 280 such spots the year before we undertook this commitment to 500 the year after. So it's an enormous internal reallocation, reprioritization of resources. We created an Office of Experiential Education staffed by an amazing former student who, as a student, had launched one of our most successful clinics. And I think that idea that this is from the bottom up, the ideas for clinics, for intensive programs, don't come from a central planning document. They come from the academic, intellectual, and social justice entrepreneurial commitments of our faculty and our students. So that commitment to do this in a way that is connected and coherent and holistic, I think has been at least essential from our point of view. But I want to suggest that that praxicum is not, again, the only incarnation one can imagine. We have many situations of summer internships or the placements pro bono and public interest that I mentioned. I would consider many of these experiential kinds of learning, but again, they don't fit with what will give academic recognition to, and that's an important distinction as well, because not every kind of good experiential component will merit academic recognition, and the reverse might be true as well. There might be things you give credit to, like a simulated in class environment, that wouldn't necessarily achieve other goals of being in the community or creating those kinds of interactions. Students want this, and of course we have talked a number of times about the pressures on students, and they want it for a host of reasons. It is simply a more fun, exciting, and engaging way to learn. It's rolling up your sleeves to see what you will be able to accomplish in this domain. There's a belief that it will better position you for career goals. There's a belief that it will better prepare you for a whole variety of other careers. But what is undeniable is that it's enormously popular with students. We, of course, have the other problem when you make it a universal opportunity, is that some students simply don't want to take advantage, and we say to them, as we say if they don't want a public interest placement, that's not a choice that you would come to Osgoode to exercise. The choice at Osgoode is which among the wide and diverse array of these opportunities will fit. If you don't want that, this simply isn't the school for you. And differentiating, coming back to Margaret's talk, law schools, to say we stand for something distinct in the firmament of legal education is, I think, remarkably important. It doesn't mean if you want to bathe in legal theory that you ought not to come to Osgoode. I think you should. And I think we have as good a program as any in those conceptual areas. It means that it needs to be paired with something else that you wouldn't have that paired with in other schools. And so on this, I just want to share my own experience as I try to describe why I'm so bullish on the experiential future. I wanted for some years to teach a class in mental health law and justice, and the good thing about being an admin law specialist is you actually specialize in every other field in law school as well, which is why it's been lost on me why we have other classes if you could have admin, but that's a debate for another venue. So in this, of the many instantiations of admin justice, I hadn't really been able to delve deep, and I thought, how will I? Well, there's a literature, and I could bring in a guest speaker, and I could bring in ideas, and we could do problem solving. But I happened to be talking with a former student of mine who's in-house counsel at the Center for Addiction and Mental Health, CAMH as it's known, which is a globally recognized university-based center. It's a hospital, it's a research facility, and it's an incarceration facility for people committed against their will, either because they've been found not criminally responsible but subject to medical treatment or as part of a civil process. In any event, we were talking about the legal problems, and I said, that's amazing. How do you find enough time to explore all of the dimensions of a world in which these all come together to be a prison and a hospital and a university, in which the issues for people could not be more compelling, the rights-based issues, regulatory issues, policy issues, resource issues, nature of our culture issues, inclusion issues. And she said, I don't. If I had 10 more of me, I would still not run out of the huge questions that ought to and demand more exploration. The light bulb went off for me. Why don't I bring 10 students down? And then there will be 10 of you. We'll supervise them together. They'll each have a CAMH lawyer, an Osgoode professor. You'll come up with the problems. They'll choose from the range of problems so that it fits their interest. And we'll together bring them into contact with the doctors, with the policymakers, with the advocates who sue CAMH on a regular basis for wantonly violating the rights of vulnerable people. We'll do all that. And at the end, they'll have a grade, but they'll also have an exposure to, an interaction with this field that will be unlike anything I could have done or simulated in a classroom. And so that's precisely what we did for these 10 Osgoode students. And you know, they had their own light bulbs go off. One was exploring the nettlesome issue of doctors being under a mandatory obligation to convey to the transportation authority if they believe someone may be at risk to be a driver. Well, many people who are addicted will be at risk to drive. And yet nothing can undermine a physician-patient bond more than ratting out your patient and they're losing their license and maybe their livelihood. The idea is the Ministry of Transportation is supposed to then investigate whether this person actually would be at risk, but of course they don't. They just strip the license of everyone who they receive this notice for. So I said, well, what do other provinces do? There must be other solutions. She said, well, I don't know. I said, well, how would you find out? So she came back and said, look, I went online, I got nothing. No one has any answers to this. And I said, well, why don't you call them? She said, can I do that? I said, you know, these are public bodies, you're a citizen, call them. And she called every province, and she got, you know, in some cases, you know, call services in which she went in circles. One province, she got the minister, who had, of course, no answer, but it was a very memorable experience to chat. And by the end, she had an answer in primary research that had heretofore been unknown to anyone in Canada on how each province responds to this clearly unjust situation. Some really great ideas came out of this. CAMH asked for permission afterwards to circulate her paper to their own roundtable and ultimately make its way into their government relations. But it made clear to the students that you're not there to write what CAMH wants to hear, you're there to write what the best answer based on your research is. And they went into guidelines, and they went into bylaws and legislation, case law, policy making, interdisciplinary work. So that's the kind of experience I mentioned because it shows the juxtaposition between experiential learning and deep commitment to a knowledge-based community, research-oriented, scholarly, validating, should not be tolerated. And if you've read the ABA task force report of the last few weeks, you'll know that we can't reiterate often enough that scholarship enhances experiential learning. It doesn't happen at the expense of it. And this again comes back to Harry's watchful words on experiential on its own isn't the answer unless it includes this commitment to the knowledge community. And that's where I think the CAMH example is simply one of many we can imagine, in addition to Doug's excellent work at Western and the other clinical leaders in other law schools to bring legal services to bear. Okay, so we've talked a lot about the influence of the profession and markets. I won't add that. The CAMH experience, which plays out in many different collaborations at Osgoode, is worth mentioning. Most recently, our disability intensive with ARCH. Because getting the law school out of the law school, and together with communities of NGOs, of industry, of others who share in legal education, to me is one of the richest and most underutilized potential in legal education. I think the future will be rich with it. It answers the question, how can you afford to have clinical and intensive program after clinical and intensive program? It's because you find kindred spirits that believe in the knowledge community, believe in experiential learning, want to be a part of it, and will add their resources to yours to make it happen. And then, let me see if I can actually get to one other slide, or will we perpetually be on this one? See, now we have the fade. So let me conclude with why it's good. Well, I've said some and maybe enough about why I think it's just better legal pedagogy, a better way to teach, a better way to learn. It creates better law students who are problem solvers, are simply better than law students who have specialized knowledge, even those who have specialized knowledge and analytic abilities. If they haven't actually put them to the test, the humility that comes from trying to solve a problem that is unsolvable is like nothing else we can possibly teach, especially if you end up with the hopeful note that one should, that doesn't mean we don't continue to look for creative and progressive solutions. It means we don't have the arrogance to think everything will neatly fit together. And as I'm at time, I won't go into more about why I think it also leads to better law schools, but I've hinted at that through community engagement, collaboration. An outwardly looking law school rather than an inwardly focused law school is simply a better law school for these times, and I would suggest for all time. And then lastly, better leaders, and not coincidentally, I wanted the last thing to be said on this, not the first thing. It happens to also produce better lawyers for those who choose to go on, but that ought not to be the reason we do it. The reason we ought to do it is because it creates all those other betters. And that's why I'm bullish on it. That's why it's been a journey of great discovery and enthusiasm and passion for me, and pride to be at an institution that puts this front and center. And it's not without, again, its rightful skeptics. I hope we'll get into that in the Q&A, because there are some, of course, reasons to be justifiably scrutinizing these programs when they come up, how they're funded, how they're delivered, quality and oversight, and all the rest. So more on that to come, but thank you for hearing me out on what I hope has been a good news story to hear, as it's been to tell. Thanks very much.